Okay, welcome everybody. Thank you for joining us today for another Vanguard Insurance Agency employer education event. So for those of you that are with us for the first time today, welcome. We obviously have a lot of familiar faces as well, but we started this in 2020 during the beginning of the pandemic as a way for us to be able to still provide relevant content to our clients, our partners, our friends. Obviously, over the course of the year, as things were changing fast and furious, it became more important for us to be able to provide this, and hopefully we'll be able to do it in person someday, and hopefully that's soon. So for those of you that don't know us, the Vanguard Insurance Agency is an employee benefits consulting firm. We are located in Melville, Long Island. We have been in the field of employee benefits and established now for over 22 years, and work closely with small to mid-sized businesses and nonprofits, providing benefits and education surrounding employee benefits for the employees of organizations that are looking to provide value in the method of becoming an employer of choice and helping them attract and retain top talent. I just do want to mention a couple of things before we get started. If you have not received it already, we sent out our 2020 year in review compliance bulletin. If you didn't get it yet, it went out probably about 2 weeks ago. Just type your name in the chat if you didn't get it and you want to receive it, and we'll send it to you. The first quarter of 2021 was sent out last week, and the same goes for that. So if you want to receive it, just let us know and we will send it to you. We typically add anybody that joins one of our compliance events to our compliance mailing list. There is an opt-out on there. So if you do receive an email from us regarding compliance information and you don't want to receive it, just opt out, or simply just put your name in the chat and tell us we don't want to receive it, and we'll make sure we don't add you to our list if you do not want to. Also wanted to mention Vanguard is a founding partner of the Nonprofit Resource Hub. I know we have some nonprofits with us today. If you haven't become a member of the Nonprofit Resource Hub yet or don't have any information on it and would like some, please reach out to us. You can put your name in the chat. We'll make sure we get you that information as well. The Nonprofit Resource Hub was established to provide education resources to the nonprofit community. So we definitely want to get that information to you if you don't have it already. And just some housekeeping items before we get going. I will be monitoring the chat. So if you please keep yourself on mute, and so we can avoid any background noise. And you can type all of your questions in the chat. We'll stop along the way, and I'll definitely feed Amanda some questions along the way so we can keep this in real time and get to anything. I know Amanda has a full plate of what she's going to discuss and review, and there's certainly a lot to cover, but along the way, we definitely will answer any questions. Our upcoming events, so look out for the invites. We have an elder care presentation that will take place in May from Jim McTighe over at Mass Mutual. And we also have Tildet Barron, who will be joining us again in May to discuss wellness and stress in the workplace and how to take the temperature of your organization to make sure that the stress levels, especially coming out of a year that we've come out of, are in normal fashion. So with that, I do want to introduce Amanda and thank her for being with us today. So Amanda is the head of the labor and employment practice at Ellenoff Grossman and Scholl. She represents clients primarily in the fields of labor and employment, including litigation, counseling, and preventive education with regard to employment discrimination, harassment, labor relations, employment contracts, severance agreements. And so she's spoken with us in the past. You might remember, you might have been involved last year when things were coming fast and furious at us in the beginning of the days of PPP, which has now become a household term. She was gracious enough to join us back then and provide some incredible content. So I think this was another great time for that, as things seem to be changing daily. So we thought and we asked if she would join us, and she graciously accepted. She's been a great partner to the Vanguard Agency, and we appreciate her joining us today. So with that, Amanda, I'm going to turn it over to you. Thanks for being
Hi,
here again.
thank you. Thanks, Ed. Good afternoon, everyone. A note about questions. So Ed said, type your questions in the chat box. We do want to answer all your questions, and I will, if Ed doesn't disagree, I don't mind if you just unmute yourself and speak out if you have a question as well. But I will give you a caveat, which is about an hour ago, Ed calls me, just I think check in. And I said to him, oh, I'm studying. He goes, you have to study? And I said, yeah, because the government changes the rules every day. So we will do our very best to answer all of your questions, and what can't be answered in real time, I'll get back to you on, because these rules are changing fast and furious, as you likely know. So give me 1 second, and I am going to attempt to share my screen here.
And of course, that is fine with me. So feel free to unmute yourself and ask any questions along the way.
So Ed, do we now have the presenter view?
Yes.
Okay,
Looks like
very
that.
good. All right, so let's start by talking about economic aid. Hopefully, as you've heard, round 2 of the PPP is out. The eligibility was it had to be 500 employees or less per location. You have to be able to show a 25% decline in gross receipts over 2019. You were entitled to 2.5 times monthly payroll costs, or 3.5 times if you were a restaurant or hotel. It was capped at 2 million per entity. The loan forgiveness works pretty much the same as the first PPP, except that there was some expanded use of the funds. And the deadline to apply is now May 31st. So if you have not received your PPP, your second rounds of PPP, and you wish to apply, go ahead, you still have a little time. The employee retention tax credit, new information, some new documents came out this morning from the IRS. Hopefully, as you've heard, up to 70% of up to $10,000 of qualified wages per employee per quarter in the first 2 quarters of 2021 are eligible. So it's a tax credit of up to $14,000 per employee. You can qualify for this even if you got the PPP, but you can't use the same cost twice. So if you're being forgiven for those payroll costs under the PPP, you're not going to qualify for the tax credit. Additionally, you have to be able to show some real hardship. You have to be down 20% quarter to quarter. You have to be under 500 employees. We're going to talk about that in a second, because there is a one way if you're over 500 employees, if you're severely distressed. So it was extended to December 31st, 2021, but it's only the first 2 quarters. So we don't know, it's only $14,000 right now. Maybe they'll extend the next 2 quarters, but I think that might be what's causing some confusion. So they extended for the whole tax year, right, through December 31st, 2021. But right now you're only eligible for the first 2 quarters if you are less than 500 employees. So to qualify, you have to have either fully or partially suspended operations due to COVID-19. And you have to show, I'm sorry, a 20% reduction in gross receipts compared to the same quarter in 2019. There is some new eligibility if you are a recovery startup business. So if you were brave enough to start a business from February 15th, 2020 through to now, there are some particular ways that you can qualify. And if you have more than 501 employees, then if you had that many in 2019, and you can show that you are, I'm trying to remember the term, severely distressed, you have only 10% of the gross receipts, 10% or less of the gross receipts from in the same quarters 2021 to 2019, then you'll be able to claim this these tax credits as well. Talk to your accountants about this. It's something that the accountants are overseeing, and it's really a benefit to many employers. As you probably heard, the American Rescue Plan Act, people are calling it the ARPA. We started out by calling it the ARP, and I guess the Association for Retired People didn't like that. So now it's the ARPA. We got a lot of new acronyms during COVID, as I'm sure you know. You have a 1.9 trillion stimulus package that was signed in. Hopefully you got your stimulus checks if you were entitled. 1,400 for single filers, but you had to earn less than 75,000, or 2,800 for joint filers earning less than 150,000. Hopefully your employees have gotten these stimulus checks and are taking advantage of them. One important thing to note is that it also provided a COBRA premium subsidy. And I think that this has been a little known benefit, but a benefit that has a very, very big impact. If somebody lost their job during this COVID period, and they were eligible for COBRA premiums between April 1, 2021 and September 30th, 2021, either the employer or the insurer has to pay those COBRA premiums, and that depends on what type of insurance you have. So it's likely your insurer who will pick it up, but I can't tell you for sure without knowing what individual type of plan you have. I'm sure Ed has people that can advise on that. But when you pay out the COBRA for the individuals, you get a tax credit, so it doesn't actually, at the end of the day, cost you anything. The person has to be an assistance eligible individual. That's what we're calling them. And to be an assistance eligible individual, they have to have lost group health plan coverage due to an involuntary termination of employment or a reduction in hours. And they had to be eligible, as I said, between April 1 and 9/30. But here's a big but on that. They didn't have to have elected COBRA coverage when it was first made available. So if somebody was terminated, laid off in January due to reduction in hours or a RIF, and they didn't elect COBRA, they have to be given a new option to elect COBRA. So there are new COBRA notices that employers are required to send out. If you have a COBRA service, I'm sure that they are sending it out for you. The Department of Labor came out with the COBRA notices, I don't know, several weeks ago, maybe a month ago. And you need to get those out if you have employees on COBRA. I think we have some restaurateurs on the line. So one of the important things that the American Rescue Plan did, part of it was the Restaurant Revitalization Fund, the RRF,
okay.
another acronym that's getting thrown around a lot. And it allocated 28, I'm sorry? Oh, it allocated 28.6 billion
Okay.
for grants for restaurants who have 20 or fewer locations. If you're a publicly traded company, you are not eligible. They are saying that the 28.6 billion is not nearly going to be enough. So we're going to talk about applications in a minute. The grants have to be used on eligible expenses, but this, unlike the
get to
PPP,
move
this
the,
isn't a loan that then has to be repaid
cursor around a
if
bit.
it's not forgiven. It's an actual grant. And the reasons you can use these grants are very, very broad. Pretty much anything that has to do with operational expenses, payroll, rent, sick leave, all kinds of legitimate business expenses. You can't go buy that blue Ferrari. You might have seen the guy who got in trouble with the PPP for that. But in fact, you can do what you need to do to keep your business open. One additional interesting change is not only can you pay back rent with this, and not only can you pay mortgage interest, which was allowed under the PPP, but with this, you can also pay mortgage principal. So there's a lot of very, very broad uses for it. It's a maximum grant of 5 million per physical location, but up to a maximum of 10 million if you're a group. How you calculate depends upon how long you've been open. Most restaurants, we're going to assume for the purposes of this, would have been opened prior to January 2019. And you take, I'm sorry, I think that this should have been 12/31. You would take your 2019 gross receipts and you minus your 2020 gross receipts. And you have to subtract also your PPP loan amount. So as you can see, it's a pretty simple formula. You want to make up what you lost. They want to get you back to your 2019 income level minus whatever else you got from the government. If you started operations partially in 2019, you have a different formula. And if you started operations later than that, there is again a different formula, but it's all fairly pretty simple and straightforward. And the idea is to give you a grant that gets you back to your full 2019 level, which is pretty remarkable. But as I said, they do not think that the 28.6 billion will be enough for all the need. So if you are a restaurateur, you should prepare to apply. The portal is going to open Monday at noon. Go onto the SBA website, restaurants.sba.gov, starting Friday at 9 a.m. And you can make sure that you have your account set up in advance. There is guidance out there, including a program guide, FAQs, and a sample application. There is a way to set this up to interact with your POS system, if that makes it easier for you. But make sure that you go through all the guidance in advance, prepare the required documentation, get on and register. You should really do this. So I hope that they've learned their lesson and that this doesn't crash Monday at 12 p.m., but the need is huge and there is a race on and everybody's saying that. And it sounds like, you know, like we're encouraging hysteria, but I think it's real. I think that, you know, the first in line are going to get the money. So apply as soon as you are able. We have a lot of information on our website, which is www.egsllp.com. If you go to our website and look under labor and employment resources, we have all the SBA guidance and the FAQs and the sample application embedded in our client alerts that are on that site. Also, you can go to the SBA website and find the same. I'm just going to pause for a second, see if we have any questions. We're good? Okay.
I don't see any in the chat as of right now.
All right. The American Rescue Plan, it made a voluntary extension to the FFCRA. I told you we got a lot of new acronyms with COVID. It's the Family First Coronavirus Response Act. And what happened was it expired in December and everybody was like, well, what happens now with that? Well, they went ahead and extended it, but at least they did it on a voluntary basis. So this is not mandated leave or pay anymore. However, if you do pay your employees for leave related to COVID, you can get a tax credit. So I think that this was I hate to sound like a cynic when I say this, but for a change, this was like a good thing that the government did, I think, for employers, because under a lot of other laws, including the New York State COVID leave law, which I'm going to talk about in a minute, you're required to pay employees anyway. So, and under the sick leave law, you're required to pay employees anyway. So you can sort of double dip, for lack of a better word here, and a lack of a better term, and you can pay under the laws that you're required to pay under, and you can still put in for your tax credits under the Family First Coronavirus Response Act. The key here is good documentation, because sick leave for a reason other than then is qualified other than coronavirus related is not going to be eligible for the tax credit. So here's how it works. If you employ 500 employees or less, you can give up to 80 hours of emergency paid sick leave for COVID related reasons. There's also expanded FMLA of 12 weeks. And employers get a tax credit against their payroll taxes when you make payments. So if the employee is unable to work, and it's really because of any COVID related reason, they're quarantining, they have symptoms and they're seeking a medical diagnosis, they're obtaining the vaccine, they are recovering from adverse reactions to the vaccine, or they're going for a test or waiting for the results of a test, you can get, the employer can get a tax credit up to $511 a day, or it's $5,110 in the aggregate per employee when they take this sort of leave. So you can also cap the pay. If the employee isn't otherwise entitled to their full pay for some reason, you can just agree to give them this amount of pay, and then you get, let's say that they, for some reason, have exhausted all their other sick time, New York COVID leave, which we're going to talk about in a minute. It's almost impossible to exhaust that these days. But let's just say that they've exhausted all their other paid time. You can still pay them for this and get the tax credit, so it doesn't cost you anything. The real key here is documentation, right? So you want to make sure that the person that you're documenting it correctly. We have a form that we suggest employers use to keep track of it. Because usually, people call out sick and you don't keep great track of why. Here you have to keep great track of why, because after your first 10 days runs out for your $5,110, you can get an additional tax credit of 2/3 of their regular rate, up to $200 a day. So an additional $2,000 for the employee. There's also an expanded FMLA, which is 12 weeks of the job protected leave. And again, you're entitled to that 2/3 of what the employee makes, up to a maximum of 200 a day, or 12,000 aggregated. So there's really, most employers we're finding are paying people out a lot for COVID related leave. And there's really tax help available to you. You must keep track and get the information to your accountant. So, New York quarantine leave.
Hey, Amanda?
Yep.
Yeah, before we get to that, a question that we actually got from a client recently might be helpful to all. As far as the tax credits go for the employer, what would happen in a situation where an employer did not claim the tax credit in the quarter that the leave took place? Is that a situation where they could amend that return later on, or can they claim those tax credits in future quarters? Do you know?
I don't know the answer to that. I would suggest that that's a question for the accountants. I would always assume that you can amend and take it, but you're going to need documentation.
Got it. Okay.
New York quarantine leave. So this was a crazy law that got put in pretty early, where New York State said, look, people are going to have additional job protection, and depending on the size of the employer, some additional pay if they have to quarantine themselves, or if they have to take care of their minor dependent child who has to quarantine. And there was a lot of kooky aspects to this, because at first they said you had to actually get an order of quarantine. So you weren't entitled to this. You might remember, I bet you I said this to you a year ago, but you don't have to pay this and you don't have to give this leave unless the employee has an order of quarantine. Well, little did we know when this was passed in like March, that there was going to be no way possible for anybody to actually get an order of quarantine, because the government was quickly overrun. So it took New York City just a little bit of time to say, well, you can self you can basically write yourself an order, and the whole thing has gone out the window. If somebody has to quarantine because of the rules you know of, or they're caring for the child who has to quarantine, you got to provide them this sick leave. So if you have 10 or less employees and you have a net income of less than 1 million, you have to provide job protection for the length of the quarantine. If you have 11 to 99 employees, or your net income is greater than 1 million, right? And you have 10 or less, greater than 1 million though in net income, you have to pay an additional 5 days of sick leave, and they still get job protection for the entire quarantine. Employees can apply for paid family leave for additional pay. So in other words, if you have between 11 and 99, you're required to pay for the 5 days, but they have to be out for 10. They can get the PFL insurance through New York, which I hope by now everybody's familiar with. And if you have 100 or more employees, you have to pay 14 days of paid sick leave plus job protection. And the 14 paid sick days is really, it's 2 weeks. So I'm not, you don't have to go into your third week if you're thinking like, well, a week is 5 days. No, it's 14 days of paid sick leave, so 2 weeks. And this is, the pay is really if it's only the person's own, the employee's own quarantine. If they're out because they're with their minor child who's quarantining, they can apply for PFL benefits, but you don't have to pay them this additional money. So what I was explaining before, just to reiterate, is that there are many circumstances where a person is entitled to New York quarantine leave. I mean, I don't know about all of you, but I mean, we get calls still every day from employers confused and disbelieving of how many employees are out for quarantine leave. And I mean, even myself personally, I've had to quarantine 3 times, I think, during this COVID period. So it's been very prevalent, but you can pay this quarantine leave and take your FFCRA tax credit. So that should be of a little assistance to you. So one of the things that happened in 2001 is that it's pretty clear that individuals can take up to 3 quarantine leaves, and you have to pay them for up to 3. In the beginning, we were like, no, it's like everything else, like it's one and done. Nope, that's not the case. 3 people get to go out 3 times, and you have to pay them if you're of the right size for those 3 times. If you require a very important other provision is that we have some employers who want to be very, very cautious. And sometimes the employee is not required to quarantine, but the employer is insisting that the employee quarantine, not come to the office, not work. I mean, you can make somebody stay home and work, and we're going to talk a little bit about that in a minute. But if the person can't work and you're forcing them to stay home, you're a restaurant and it's a server, and the person does not technically need to quarantine for whatever reason. They've had exposure to exposure. We've had a lot of questions about that. If you're exposure to exposure, your husband was exposed to COVID, but you weren't exposed, you're exposed to your husband, do you have to quarantine? No, that's never been the rule. But we've had restaurateurs who say, I think it's a risk. I don't want this person here because of bad publicity, because we could cause an outbreak. We could be a hot spot. We could have all these problems. Fine, you can do that, but then you must pay them under this law. So testing, we've had some questions about testing. Can you require employees to test? So you have an employee who's exposed, has had, like I said, exposed to exposure, and you say, okay, fine, I'm not going to make the person quarantine, and I want them to work. I want them to come to work, but I want them to go get tested. And that's fine. You're allowed to do that. Do not administer the test yourself. That opens a whole other can of worms that we would never, ever recommend. But send the employee to get tested. But no, that the time that they spend getting tested, if you are forcing the test, is compensable work time, including the time they're waiting and the time that they're traveling. You must pay them for that. You should also pay any out-of-pocket costs for the COVID-19 tests. Then again, this is only if you are requiring the test. If they go on their own or they're otherwise required to test for some other reason, they want to get out of quarantine, it's not your problem. But if you are mandating the test, and you have to pay for the time and the cost of the test as the employer. The quarantine rules, it's as you probably know, they are never done. They are forever changing. So if an employee tests positive for COVID, they must quarantine 10 days from the date the test was taken. If they are still symptomatic after 10 days, they have to quarantine until the symptoms are gone. They are paid, really till they are fever free without medication for 24 hours. That's the rule. They can't feel better in 5 days and say, I'm good now, I'm coming back. They can't. So if they're positive, it's 10 days or until fever free 24 hours, whichever is longer. If somebody has symptoms and they've been in close contact, but they haven't actually tested positive, the rule is exactly the same. 10 days or until they're fever free for 24 hours, whether or not they've had a test or not. That's if close contact and symptoms. An employee who has had close contact but no symptoms must quarantine also for 10 days. But here we've gotten some relief lately. They are exempt if they're fully vaccinated. So if they're fully vaccinated, even if they've had close contact, you don't need to worry about it. They don't have to quarantine. Or if they were diagnosed with tested positive for COVID within the previous 3 months, then close contact, you don't have to worry about. Employees who are experiencing symptoms but have not had close contact with a person, they have to quarantine for 10 days, have been fever free without the use of fever reducing medication for 24 hours, or these people can test out, right? So you have symptoms, but as far as you know, you haven't had contact, you can test out. We can assume you're just having an allergy attack or whatever the other. It's like nobody can just get regular sick anymore. But you can test out. The whole thing, I'm sure it was drilled into you for a while. If you traveled, you had quarantine requirements and testing requirements while you were in your foreign location, and then when you came back to New York State, this is all gone with the exception. So you don't have to quarantine if you travel. You don't have to test here if you travel. But there is still an international requirement that if you are boarding a plane to the United States from an international location, you must test prior to getting on that plane. You're going to have a negative COVID test prior to getting on the plane. And right now, they're saying, I'm sure that this is going to change any day, but they're saying it's irrelevant whether or not you've been vaccinated. So you still have to get your negative COVID test. Ed, did we have a question? I thought I saw something pop up. No?
Yeah,
All
no,
right.
somebody was just asking if they could get a copy of the deck, and I assume we could get that.
Yeah, sure. Absolutely. Yep. Absolutely. Absolutely. So the hot topic of the last couple of weeks, vaccination. It's a great surprise to many that you can require your employees to vaccinate. I thought for sure we were going to start seeing all kinds of laws pop up that you can't, but in fact, the government has gone pretty strong in the other direction and said, employers, you absolutely can. But there are 2 caveats under the law. The first is if you have an employee with a disability. An employee with a disability, you have to engage in this conversation regarding reasonable accommodations, same as you do for any other job requirement when the person tells you they have a disability, which prohibits them from fulfilling the job requirement. So we always jump to the question of, Well, what disability would stop you from getting the vaccine? You know, think smaller than that, because it might not be an entire um, uh, prohibition on the vaccine. It might be that you have an employee who has some sort of a disability where they are not able to work. The reservation systems are going out the window. All this is changing so fluidly, but previously that you had to get on these reservation systems, maybe they couldn't do it. Maybe your reasonable accommodation is you help them. You have an employee who can't physically get to a vaccination site. Maybe your reasonable accommodation is you help them work that out. Maybe there is really a reasonable accommodation that does not allow the vaccination. What do you do? Well, you try to see if there's other ways that you can have the employee in the workplace safely, whether it's partitions, whether it's making sure that they work in their own individual spot, or whether it's allowing them to continue working from home. You are allowed to require documentation regarding the disability and the accommodation needed. So same as, an employee who says to you they need to be in I've had, we've had everything from, soundproof offices, or I need different lighting because of my disability, or I need a different schedule because of my disability. Same as those people who have to engage in interactive process to figure out what reasonable accommodations can be provided. You need to do the same in this situation. The same goes for a sincerely held religious belief. This one is much more challenging because it's very hard to figure out what's a sincerely held religious belief. It's a surprise to some, but the government has come out and is saying it routinely that there are no major religions that actually are against vaccination as a whole. So what's your sincerely held religious belief, and why can't you get vaccinated? And can we make an accommodation? Again, can the person continue to work from home? Can they be screened off by some sort of plexiglass? Can they have to have their own space where they work? Or maybe there is no accommodation that's reasonable depending upon the person's job. And in fact, the person would be deemed to be an unreasonable risk to the health and safety of the public or the coworkers, and or to themselves, and the individual will have to be fired. It's a very, this is fraught with risks. And if you decide to make your vaccination policy mandatory, you really need a vaccination policy, and you have to be committed to upholding it. So it has to be upheld in a non-discriminatory manner. And sometimes that could result in high performers maybe being terminated, so you got to be, sort of be careful what you wish for if you want a mandatory vaccination policy. In terms of a voluntary vaccination policy, we're seeing more clients doing voluntary, but I will tell you that as vaccinations have become more prevalent and they're more available, we are getting many more calls about mandatory. But in terms of voluntary, what we've seen, a lot of employers are offering incentives. You can have an extra vacation day if you get your vaccine, or a bonus, $200 bonus. So we've seen incentives mainly, and also information and assistance, and employers like going out of their way to try to help employees get their vaccination. You are absolutely allowed to require proof of vaccination. Just be careful, because you don't want a lot of other medical information to come with that. You can just ask for the vaccination card, or a copy of the Excelsior Pass, which I think people are more and more starting to get. In New York, you have to pay for paid time off. Surprise, surprise, employers, you have to pay for more time off, but you got to pay for time off, at least for a good reason, I think, in this case, 4 hours per shot. So up to 8 hours total. You are not required to pay 4 hours. If it doesn't take the person 4 hours, it's the amount of time it takes for them to get vaccinated, up to 4 hours per shot. We get a lot of questions about, well, what if the person is getting their vaccine off working time? Must we still pay for it? And the answer is no. You don't have to pay for it if they're not otherwise scheduled to work when they're getting their vaccine. So smart employees will schedule it when they're supposed to be working. But if they don't, you're not required to pay for it.
Amanda, on that
Yeah.
theme, you mentioned before that when we were talking about testing, I think you kind of kiddingly said, don't do it yourself if you're doing the testing. But so we're in a society where flu shots have been done on site at employers for many years, right? And that's become a commonplace for carriers, employers to provide this kind of service. Do you see any challenges along in this theme with employers at some point providing on-site vaccinations for this, or even testing for their employees if they're not doing it themselves?
So I'm glad that you asked that. That's a great question. So providing it on site through a third party is okay. Don't do it yourself. So I know it sounds funny, but we have a lot of nonprofit clients who are related, if you will, to the healthcare industry, and they have a lot of doctors on payroll, and they say, well, so if we can get tests, why can't we have our own doctor do the test? Because you don't want this sort of private medical information that's going to come with that as an employer, right? As an employer, you're not a healthcare provider. You're not covered under HIPAA. You're free of a lot of the regulations that go along with this sort of stuff. Once you start actually administering medical testing, you're going to be covered. So don't do the tests or the vaccines yourself, but there's nothing wrong with inviting a third party onto premises to do it. And they're the ones who gather the information and keep the records and do whatever, as long as you as the employer are not privy to that. No, I don't see any issue. In fact, if there's anybody on this call, I have to get out a client alert on this. There's a bus that a couple buses that an organization I'm involved with has out there, vaccination buses, and they're particularly targeted to the hospitality community, but they will put a bus outside of your restaurant or catering hall to make it easy for your staff to get vaccinated. So if anybody, I can get you more information, that let Ed know, and we'll get you the information. Also, just while I'm on that topic, if you'd like to be added to our client alert list, we put out, sometimes it feels like daily, but you can always unsubscribe if it's too much. But when things change, the rules change, new applications come out, or just, back to the regular laws, when they change, we put out client alerts to keep our clients in the know on what's going on. So if you'd like to be added to the list, please maybe put your email in the chat, and we'll get you on the list. Any questions about vaccines?
Don't see anything in the chat as of now.
Okay. Where are we? Office reopening. For those of you that are in regular office settings, we're aware that many offices have remained closed or have entered into some sort of a quote unquote voluntary reopening, where either they're just letting people go in when they want, or they're turning a blind eye and people are just going in when they want. So the caution there is that, offices were allowed to be open since last June. I think the date was June 22nd or so, maybe June 24th. But you are required, whether it's a few people going in or whether you've mandated everybody come back to work, you are required to fill out an affirmation to New York State It's on the website. You're required to have a health and safety plan. The affirmation that you fill out to New York State says you have a health and safety plan and you're going to require people to wear masks and stay 6 feet apart, blah, blah. You're going to provide mandatory health screenings and PPE. The mandatory health screenings are the questions. You're supposed to have a set of questions. It's now down to 3 if you're a regular office environment. But when we started this, it was like 12 questions and then follow-up questions. I think like I said, I think we're down to 3. That if you answer no to all of them, of course, then you get a little thing, oh, you're welcome to come back to the office. But you are required to be doing these screenings before people enter your office space. We heard in the beginning about a lot of enforcement. We're not hearing about a lot of enforcement anymore, but I still think it's very, very important that you keep up with the reopening requirements and do your affirmation to New York State if you haven't, and make sure you have your safety monitor and your plan in place, because here's why. The lawsuits that have been filed are just the tip of the iceberg. They're going to come, and there's going to be a lot of them, and they're going to be creative. And we're going to talk about the HEROES Act in a minute, which is going to implicate this. But even if the HEROES Act, which is up for signature by the governor, does not pass, it is still likely that you are going to get lawsuits that say, I got COVID in the workplace. I should not have to only be limited to workers' comp. I should get personal injury damages because my employer was grossly negligent. And what are they going to look to say whether the employer was grossly negligent or not? They're going to look to see if the employer followed the requirements that were out there, right? So as you may know, just taking a step back to explain it a different way, when an employee is injured at work, they're limited to workers' comp. You have insurance for that. Generally, employers take the position of it's not really my issue. We're sorry the employee was injured at work, but we have insurance for that. They fight it out with the insurance carrier. No big sweat to us, right? I know people get aggravated about their premiums. I'm sure they complain to Ed, but the reality is you have insurance. You have insurance for torts as well, torts being personal injury, but or I hope you do. Most employers do, but the damages are not limited in the same way. This is the same as, I'm walking down the sidewalk and I trip and I break my leg and I sue the person responsible for the sidewalk and the jury awards me, $1 million. I burn myself with hot coffee and the jury awards me whatever. So you do not want to be open to those sorts of personal injury lawsuits by your employees. And we've seen some, we anticipate that they're going to be put back and told, that they're going to be put back in the workers' comp realm and be told no, and then the workers' comp people are going to turn around and say, well, it's impossible to prove that you got COVID at work. But there are some wrongful death suits out there. My son got COVID. Well, I think there's one against Walmart. My son got COVID when working at Walmart. He died. I'm bringing a wrongful death suit against Walmart because they were grossly negligent. So I shouldn't be limited to my recovery in workers' comp. You want to be able to turn around and say, look, we don't know where you got COVID, but we adhered to everything that we were supposed to do. So we were not negligent in any way. And at worst, it's a workers' comp issue. And then your workers' comp people will do it. So I can't emphasize the importance of really making sure that you're following the guidelines. Some legal updates unrelated to COVID-19. It's hard to say that sick leave isn't related to COVID-19, but the fact of the matter is they had passed a New York State sick leave bill that just became law during COVID. And we are surprised to see, and I think it's because everybody's distracted with pandemic related information, that many employers don't know that if you're 100 plus employees, your obligation has raised to 56 hours of sick leave annually. So it used to be New York City employers were used to this. They were required by law to give 40 hours on an accrual method. Now it's the entire state, but if you're 100 plus, you must give 56 hours, not the 40 that we were used to. And of course, there's a bunch of additional reasons. I mean, sick leave is, you just need leave almost for any reason now. It's sick leave. And you can't, and for until the fourth day out, you can't ask for any sort of reason. So you don't know why employees are taking it anyway. But if they are taking it for a COVID related reason and you document it correctly and you're paying them their full rate, you can get tax credits. So don't forget about that FFCRA. Voting leave has changed again during this pandemic period. I'm not sure why. We don't see this very frequently, but for some reason the state reversed its amendment. If you recall, in 2019, it went from 2 hours of paid leave, so then you had to pay 3 hours of paid leave. Now they put it back to 2 hours of paid leave, unless the person needs additional time and doesn't have 4 hours consecutive before the polls, between the time the polls open and they start work, or from the time they finish work and the polls close. So we're back to 2 hours paid leave for most people. A very, very welcome change, I think, during COVID, and it went largely unnoticed, was that unemployment has been expanded recently for part-time workers. So you may know that in New York State, we had this problem where it was based upon days. They used to figure out unemployment based on days. And if you worked 4 or more days, even if you were limited to 1 hour a day, it was considered that you worked. So you had a job and you were cut 50% in that job, but it was 50% in time, not 50% in the amount of days. You would not be able to get unemployment. It led to a very absurd result during this pandemic period. But now they've gotten with the majority of the states, New York, and they're doing it based on hours. So if your hours are reduced by a certain percentage, you can still get unemployment. The individual can still get unemployment, but the amount they get will just be reduced by a certain amount of hours because they're working, or a certain amount of money, I'm sorry, a certain percentage because they're working. But part-time employees or employees that have been put to part-time are not banned anymore. So that was really, I think, good news for workers. And I think most employers have forgotten that they have an annual harassment training requirement. With all the other stuff going on, it could be easy to forget that, but in fact, you still are required to train all your employees annually with the anti-harassment training. Two things that are on the horizon, and I mention them particularly because if you're active in any way in politics, or if you can go online and find petitions, at least this first one, I think both, but at least this first one, the sweat legislation, really needs to be lobbied against. And the more people behind it, the more likely it will fail. I mean, against it passing, I should say. So what the sweat legislation, it's, in my opinion, a crazy piece of legislation. It says that if an employee owes you money, they can just get a lien against your business and against you personally. So they don't have to prove anything. They just have to file a case, an FLSA case. I'm sure many of you are familiar with how many wage and hour cases are filed regularly. So if they file a wage and hour case under the New York labor law or the FLSA, their attorney can just get a lien. And the lien is against the quote unquote employer with the same broad definition that it is under the wage and hour laws. So it's not just against the business, it's against it can be against managers. It's against the 10 largest shareholders, the 10 largest unit holders, partners, anybody who has a decision, has input into how the business runs. This is really a terrible, terrible piece of legislation. It passed both houses in New York in 2019. The governor vetoed it. It stalled out in 2020, but we were told in 2020, I think the first week in March, I was told by the head of the Department of Labor The governor's going to sign it this time, and it's stalled out because of COVID. And now it's back up, and it's likely to pass both houses again. And we're hopeful the governor will veto it again, but I don't know. And it just, what it does is it puts an incredible amount of leverage. It gives the plaintiffs and the plaintiffs' attorneys an incredible amount of leverage to hold businesses hostage, because, settle with me for any amount or I'm putting this lien on. And you will be able to bond your way out of the lien, but it's just one more expense on businesses. There's no due process for businesses in this law. So it's called the Sweat legislation. It's particularly bad if you have contacts. I know a lot of people who deal with Ed and are on these calls have contacts in government. Try to speak up against it. The HEROES Act looks like it's going to pass. And essentially what the HEROES Act does is it codifies all of these rules that I mentioned before, that I said, in reopening your business, you have to do these things. Instead of just being sort of interim guidance that you're expected to follow, it makes them laws. And then it gives employees, plaintiffs' attorneys, a private right of action to enforce those laws. Again, I think that this is a very, very bad piece of legislation, because essentially what this does is it's just going to set up another cottage industry like the ADA website accessibility, if you had that lawsuit, or ADA physical accessibility, where the amounts individuals can sue you for are very, very low. I mean, I don't want to say very low. I mean, it hurts. I think it's $20,000 is the maximum the employee, but they get their attorney's fees. So it sets up a system where an attorney is going to get one plaintiff, and they're just going to go business to business, business to business, try to find a violation, bring these lawsuits, and hit you for a, $20,000 settlement over and over and over again. So the business groups are coalescing behind this to try to get the governor to veto. We'll see. The governor doesn't have the political capital that he used to. So I don't know what's going to happen with that one. I don't think we have any fast food employers on this call, but I will tell you that another scary thing, not to give you all bad news about New York State and what they're looking to do, but it's a scary thing because it's happening to fast food, and I don't know where else it'll go. Fast food employers are people that operate as a chain with 30 or more establishments across the country. And it doesn't matter if they're franchises or they're singularly owned, but the bottom line is that they're saying there's no more employment at will. That's the simple explanation for this. Fast food just cause progressive discipline and recall protocol law that they're putting in is that they're doing away with any sort of employment at will. It's going to be like a unionized environment for fast food, whether they have a union or not, where the employer will have to prove just cause for terminating people, just cause for layoff. They're going to have a certain order of recall. So the government's really coming in to tell people how to run their business even more than they were before. I think with this piece of legislation, which has passed, it's effective July 4th, that New York has now become the most regulated state in the country, surpassing California in terms of employment. So I don't know what to say, but that makes your operating environment very difficult. With that, I will see if anybody has any more questions.
If anybody'd like to unmute themselves and ask questions now, please do. I'll start with one, Amanda. One thing that crossed my mind as you were discussing unemployment, and I don't know if this is related, but maybe you have some guidance on this because I'm sure it's affected a lot of people. We're seeing a ton of fraudulent unemployment claims that, in fact, my own wife received something 3 weeks ago. We have clients who the owners of the company have received unemployment claims. Do you have any comment on that? How serious should this be taken? What should people do?
So I think that you need to take it very seriously. It's very hard to get anybody at unemployment to pick up the phone, but they have a fraud hotline. And I know we're telling people to go to the fraud hotline, and then we're getting calls back like, what are you, crazy? They never answer the phone. Um, that's what they're saying to do. They have now, because they know they don't have enough people answering the phone, they have a form that you're instructed to fill out. It's funny, Ed, you say your wife, my husband had the same. It's very, very widespread. We are hearing about this far and wide. You should also notify your insurance carrier regarding, some people have sort of crime fraud and that sort of thing. So when it's the business owner or management employees, it could maybe not just be a fraud against an individual employee who you're not really responsible for in that regard when they go to get unemployment because they're not your employee anymore. But an obligation to the business owner or to an executive who's still there and somehow gets picked up, you might be able to get some coverage for some help under your insurance policies, your crime policies, or your fraud policies. So look into that. Let Ed know, and let your brokers who have those sorts of policies know. Ed, that would be you, right? Would that be you?
No, we
No.
would be only employee benefits, but we definitely have partners for all this. So you can feel free to reach out to us and we'll get you to the right person.
But I think it has to be taken seriously, because if the person has your social security number and your date of birth, who knows what else they're doing to you?
Yeah.
So this seems to be, the widespread fraud at the moment. But if you have a feeling on it, you should also, get the identity lock and those sorts of protections, because they got your info.
Well, to that point, I was just going to say that, Amanda, we are seeing an uptick on our end for employers that are requesting LifeLock identity theft type products to be able to provide either voluntary. Some of them are actually even paying for it for their employees, and it's because of this very reason. That, along with employee assistance programs, that they're both are on the rise.
Yeah, I think that's a very good point. Away a little from the identity theft issue, but during this COVID period, we've seen really an increase in the need for employee assistance programs, because a lot of individuals out there are suffering. They may have been holding it together before, but COVID's pushed them over the edge. And, people are having a significant amount of substance abuse problems, emotional distress issues. And, it's EAPs are a good thing to be able to offer your employees.
Yeah, and on that note, it's a good segue into, as I mentioned before, one of our upcoming events is going to be about stress in the workplace. So definitely look out for that and plan to attend that. I mean, I think over the last year, what we've all been through it has impacted even the most grounded person. There's no doubt. So this is something that employers, employees, everybody is dealing with. I don't see any other questions in the chat. If anybody has, we'll take another 30 seconds to see if anybody has any chats, any questions, and we'll wrap up.
Thank you. I appreciate your guidance here. It's very good.
Good. Thank you, Shari.
Thanks, Shari.
I definitely want to echo that. This was really good, and I'm glad we'll be able to get the PowerPoint to be able to reference back to. There's a lot to reference.
Great. Thanks, Renee. And let us know if we can do anything for you in the future if you have any questions.
You got it. Thank you so much.
All right, everybody. Have a great day. Thanks, Ed.
Yep. Yeah, thank you, Amanda. I really appreciate all the great content, and always appreciate it. So thank you to you. Thanks everybody for joining us today. Have a great day.
You too. Bye-bye.
Bye-bye.